Good afternoon and welcome to the final round of the 2016-2017 Hail Moot Court Honors Program competition. My name is Andrea Hajiani and I am the chair of this year's program. The Hail Moot Court program was established in 1948 by a group of law students and was named after the dean of the law school, William Green Hale. Over the years, the program has evolved into one of the law school's prestigious honors programs. At the beginning of the academic year, the Hail Moot Court competition commenced with 40 of the most outstanding advocates in their second year class. Each of the students was selected based upon his or her excellent performance, both orally and in writing, during the qualifying rounds at the end of their first year in law school. 16 of the students advanced to the quarterfinal rounds, 8 to the semifinal rounds, and finally, 4 were selected to argue in today's final rounds. This final round represents the culmination of their dedication, perseverance, and excellence throughout the year. I am delighted to welcome you here today to support the program and its participants, and to celebrate the remarkable achievements of this year's 4 finalists. They are Taylor Ashton, James Nick Rafter, Zoe Steinberg, and Rachel Yang. Please join me in congratulating each of them for their success in the program. At this time, Dean Guzman would like to say a few words of welcome.
Well, hello, everybody, and welcome. Good to see you all here. I want to thank our judges here who will be judging the decision, Judges Donald and Berzon and Justice Cuellar. I want to congratulate the participants who are in the finals, but also all the participants who were in the various moot court rounds. Welcome, and let the festivities begin.
Good afternoon, everybody. I'm Christopher Griffin, the Administrative Vice Chair of the Hail Moot Court program. And before we begin, I just wanted to take a couple minutes here and read the facts of the competition case for everyone. So for participants or members of the board who were pretty heavily involved with these facts, go ahead and tune out for the next couple of minutes. But everybody else, here we go. This case comes before the United States Supreme Court, presenting 2 important issues regarding the scope of federal protections against sexual harassment under Title VII of the Civil Rights Act of 1964. First issue is whether the district court erred in holding that a local union and national union that had only limited shared policies and operations did not constitute a single employer subject to liability for sexual harassment under Title VII. Second issue is whether the district court erred in using a threshold remuneration test to determine that a volunteer receiving medical treatment coverage from her employer was not an employee entitled to sue for sexual harassment under Title VII. So the procedural history and facts of the case are next. The Gould Social Workers Union, otherwise referred to as SWU, or the local union for the purposes of this competition, is a member of the Federation of Social Workers, FSW, or otherwise referred to as the National Union. FSW is a national federation of local social workers unions. The local union, SWU, has 9 full-time paid employees, and a 3-member board of directors composed of paid part-time employees. FSW is larger than SWU and consists of 11 offices and 200 paid employees. In order to be a member of FSW, a local union must abide by certain overarching rules and regulations. For example, FSW can audit a local union's financial reports at any time, and it must approve any capital expenditure exceeding $10,000. Furthermore, FSW provides local union employees with a standard 401k pension plan and workers' compensation insurance. In addition, FSW requires its member unions to adopt its anti-harassment policy, which is set forth in both FSW's and SWU's employee handbooks. In April 2014, SWU's office manager, Christopher Griffin, interviewed Anna Dewan for a part-time volunteer position. That position was typically filled by individuals without a college degree. However, although Dewan had a degree, she wanted hands-on experience working with Gould's homelessness issues. As such, Dewan accepted a volunteer position at SWU, which required her to work a minimum of 25 hours per week, with the caveat that she could work from home and choose the days that she wished to work during the week. SWU provided Duan with workers' compensation insurance as well as free parking and lunch on the day she chose to work at the office. Duan began working at SWU in May 2014. Most unfortunately, however, during her first week of work, she broke her arm in SWU's kitchen. She underwent medical treatment and an 8-week recovery process, and because it did not want to bother filing a claim for workers' compensation, SWU paid approximately $10,000 out of pocket for her medical expenses. Andrea Hajiani, SWU's operations manager, was Duan's supervisor, and she was the one that assigned work to Duan. Most of Duan's work revolved around participation in political initiatives affecting Gould's homelessness problem, although on at least 2 occasions, Duan was praised by SWU officers for expanding the scope of her assignments. Duan became so familiar with Gould's homelessness projects that SWU officers sometimes relied on her opinion regarding SWU's own homelessness projects. Besides her work on SWU's homelessness project, Duan also performed administrative tasks for SWU, pretty simple stuff, including answering the telephones, greeting clients, performing data entry, and planning social events. According to Duan, not long after joining SWU, Hajiani began to sexually harass her. Hajiani had a habit of calling Duan sugar lips, and during one of SWU's and FSW's monthly joint management meetings, Hajiani used this term. The attending officers, including Joseph Peacock, who was a board member of SWU, as well as the vice president of operations for FSW, laughed when Hajiani called Duan sugar lips. After this meeting, Hajiani always referred to Duan as baby or sugar lips. Duan alleges that the harassment came to a head after work one day when Hajiani followed Duan to the parking lot, pressed her body up against Duan, and crudely propositioned her. Duan declined, and in April 2015, she filed a complaint with SWU's HR department, and because she was unable to provide corroborating evidence, so Duan was unable to provide corroborating evidence of the harassment to SWU's HR department, but a former SWU office manager, Lauren Fishelman, has since stated that she had previously reported 2 prior instances in which volunteers complained of sexual harassment by Hajiani to SWU's HR department. However, SWU refused to take action following Duan's complaint and cited that lack of corroborating evidence. Duan then filed a complaint with FSW's HR department, but they too refused to take action against Hajiani. So, after both of these HR departments failed to take any action, Duan resigned from SWU on June 1st, 2015, and filed a complaint against SWU in the district court for the District of Gould, alleging that she was sexually harassed in violation of Title VII of the Civil Rights Act of 1964, 42 U.S.C. Sections 2000E2A1. SWU filed a motion for summary judgment, arguing first that it was not a large enough employer to be subject to Title VII because it had less than 15 employees, and second, that Duan was an unpaid volunteer, not a paid employee that would be entitled to protection under Title VII. Duan argued first that SWU was subject to Title VII because it and FSW constituted an integrated employer whose numbers should be aggregated for the purposes of Title VII. And secondly, that Duan qualified as an employee under common law agency principles. The district court rejected both of Duan's arguments and granted SWU's summary judgment motion. Duan subsequently appealed, and the 12th Circuit Court of Appeals reversed the district court on both issues. As such, SWU filed a petition for writ of certiorari to the United States Supreme Court, which was granted. And that's the issue that's in front of this court today. So we're going to hear argument on both of those issues. So this afternoon, James McCrafter and Rachel Yang will argue on behalf of the petitioner, which is Gould Social Workers Union, the local union. Taylor Ashton and Zoe Steinberg will be arguing on behalf of the respondent, Anna Duan. I'm going to go ahead and invite Andrea up here to introduce the judges for today's competition. We'll get started.
Okay. The board is proud to introduce the 3 distinguished members of our legal community who will serve on our judicial panel this afternoon. Serving as Chief Justice is the Honorable Marcia S. Berzon. Judge Marcia Berzon serves in the United States Court of Appeals for the 9th Circuit. She was appointed by President William J. Clinton on January 26, 1999, confirmed by the Senate on March 9, 2000, and received her commission on March 16, 2000. Prior to her appointment to the Ninth Circuit, she served as a law clerk to Justice William J. Brennan, Jr. of the United States Supreme Court, and to Judge James R. Browning of the United States Court of Appeals for the Ninth Circuit. She also worked as an appellate advocate at Altshuler, Burzon, Nussbaum, Rubin, and Domain, a San Francisco law firm. Judge Burzon received her law degree from the University of California, Berkeley, Bolt Hall School of Law. Also judging this afternoon is the Honorable Bernice B. Donald. Judge Bernice Donald serves on the United States Court of Appeals for the Sixth Circuit. She was nominated by President Barack H. Obama on January 5, 2011, confirmed by the Senate on September 6, 2011, and received her commission on September 8, 2011. Prior to her appointment to the Sixth Circuit, she served on the U.S. District Court for the Western District of Tennessee, where she was appointed by President William J. Clinton in December 1995. Judge Donald served as a judge in the U.S. Bankruptcy Court for the Western District of Tennessee from June 1988 to January 1996. Judge Donald received her law degree from the University of Memphis Cecil C. Humphreys School of Law, where she has served as an adjunct faculty member. Also judging this afternoon is the Honorable Mariano Florentino Cuellar, who serves in the Supreme Court of California. Following his graduation from Yale Law School, Justice Cuellar began his career at the U.S. Treasury Department's Office of Enforcement and clerked for Chief Judge Mary M. Schroeder of the United States Court of Appeals for the Ninth Circuit. He later joined the faculty at Stanford University in 2001 and worked there until 2015. Justice Cuellar also served in the federal executive branch. In 2008 and early 2009, he co-chaired the Presidential Transition Team on Immigration, Borders, and Refugees. In 2009 and 2010, while on leave from Stanford, he worked at the White House as Special Assistant to the President for Justice and Regulatory Policy. Between 2010 and 2015, he was also a presidential appointee to the Government Council of the U.S. Administrative Conference. From 2011 to 2013, he co-chaired the U.S. Department of Education's National Equity and Excellence Commission. Justice Cuellar was appointed to the California Supreme Court by Governor Jerry Brown in November 2014 and began serving on the court in January 2015. The arguments today will last approximately 1 hour. At this time, please ensure that all cell phones have been turned off. Please also remain seated and as quiet as possible during the arguments. We will take a brief break following the conclusion of arguments. And now we will begin the final round. Bailiff?
All rise. The Honorable Chief Justice and Associate Justices of the United States, of the Supreme Court of the United States. Please be seated.
Okay.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting.
Good afternoon. Welcome to the Supreme Court of the United States. We will begin with the appellants, and we will hear from Mr. DeCrafter. I assume that you are reserving time, but you should let us know.
Strong. Good afternoon, Your Honors. May it please the Court, James DeCrafter, co-counsel for Petitioner Gould Social Workers Union. My co-counsel, Rachel Yang, will discuss the employee issue following. At this time, I would like to reserve 1 minute for rebuttal. Your Honors, today we're dealing with an issue of definitions. We're dealing with the issue of defining the term single employer for purposes of Title VII liability. Title VII has
the word single employer is not in the statute, is it?
No, Your Honors, but the issue that we're dealing with primarily is that the term employers here can ultimately mean that you have an aggregation of employers. And the issue that we have is how do we determine when to aggregate those employers? Now, as such, what we're looking for really is a second piece of Title VII, aside from its directive to eradicate discrimination, the piece relating to the small business exemption. And relating to that small business exemption, what we're really looking for, Your Honors, is those narrow circumstances where you have businesses that are exempt from Title VII, but really they ought not to be.
Well,
so
why doesn't the guidance in Darden that sets forth the factors test provide ample guidance for courts and individuals to determine when you can aggregate for purposes of having a single employer?
Your Honor, the factors tests that are provided by that case and Baker versus Stewart Broadcasting ultimately are overly vague, and therefore it provides a very difficult standard for courts to be able to apply, and more so for small businesses to understand what is their obligation. You shouldn't need to be a master of jurisprudence in order to know what you need to do as an employer.
But you say that it's overly vague, but in terms of the language used in those factors, aren't those fairly susceptible to common, everyday, easily understood definitions?
No, Your Honor, I don't believe that they are, clearly because you have several circuits who are applying this test inconsistently one with the other. For instance, we see that 5 of the circuits apply this test with an overall qualifier stating that in order to apply the test, ultimately we're looking for a question of who is the final decision maker between a parent and a subsidiary. Under those circumstances, we have a test that leans far more sharply towards what PAPA is trying to affect.
And you'd like us to use the PAPA test because presumably it's simpler. Like certainly you say that word, PAPA, and maybe one thinks it's as simple as figuring out if one corporation is the PAPA of another corporation. But, explain to us how you would apply that test.
The PAPA test, Your Honor?
Yes.
Yes, well, the PAPA test, and if I may clarify, it's not just that the PAPA test is simpler, but that the PAPA test ultimately leads more naturally from the language of Title VII and from which component of Title VII with which we are dealing. In this case, we're dealing with the issue of the small employer exemption. The issue of aggregation leads naturally and logically from that. Therefore, we advocate for a test that addresses that issue and not a test that's leaning towards the broad.
So work through the analysis. Tell us how you would apply the PAPA test here, and then we'll have a discussion about whether that's the proper test.
Certainly, Your Honors. As stated in the record, the first 2 prongs of the PAPA test, that of piercing the corporate veil and that the fraudulent prong, are stipulated to. So addressing the issue of directing of discrimination. What we see specifically within PAPA is an indication that what we're looking for is a case where the parent organization is not just present, but also is part and parcel to that discrimination.
But the reason, how does that tie into the reasons for exempting small employers? The reasons for exempting small employers has to do with the notions about their resources and their need for flexibility, I assume. So why does the question of whether a parent is directing them tied to those purposes?
Your Honor, in this case, I believe that ultimately what the directing discrimination prong does is, in effect, it makes the PAPA test more inclusive in that it doesn't, that one entity directing discrimination does not necessarily presuppose an aggregation in this case by saying that by necessity, when there is a direction of discrimination, we're saying that they have not only a certain level of control over them, but that they, in effect, use that level of control, and therefore we're going to make them part and parcel to the liability.
Wouldn't we want to know something about the integration of economic resources?
Yes, Your Honor, and the PAPA test does in fact address that with the piercing prong. If we look to the piercing prong, we see that we look to commingling of assets, we see to the utilizations and how integrated the operations.
But surely you'd agree, counsel, that you can have substantial economic integration and not get to the point where the corporate veil is pierced. So we're still dealing with a test that is substantially narrower than what perhaps one might conclude is appropriate if one thought about the broad remedial purposes of Title VII. Is that not the case?
Your Honor, is it narrower? Yes. However, the way the PAPA test is structured is that we have one general, more flexible standard under the piercing element, and then we have 2 elements that target specifically malignant purpose. And by allowing for 2 prongs that target malignant purpose, we're catching fewer fish in our net than we would under the Baker standard, but we're catching those fish that are the true bad actors.
But aren't we also, if we use the PAPA test, basically ignoring the remedial purpose for Title VII by setting up a structure that really makes it very difficult to get at that conduct that the statute was designed to remediate?
No, Your Honor. I think that ultimately what we're doing is the statute can still do its work. But what we're trying to do is find a way for it to do its work within the context of what Congress intended. And we have a very narrow exception and narrow circumstances of companies that don't rightly belong under that protective shield. And we're
Okay.
trying to
Let me ask you this. So under the PAPA test, what factors would you argue a court should look at in determining whether or not the parent directed the underlying activity?
I think we should look at whether or not the parent organization offered certain policies or directives. For instance, if you have a parent organization that directed a subsidiary to engage in hiring practices that favored men over women because women are more expensive to insure, that sort of scenario would be a clear direction of discrimination. We don't have anything like that.
But in
our
terms
case.
of a sexual harassment situation such as the one we have here, what would you argue under PAPA, what would you argue the court to look at?
I would say that if we saw an instance of a senior member of the organization, of the parent organization, actually engaging in a discriminatory conduct, actually participating in that conduct or giving affirmative assent to that conduct,
But then the organization would be responsible on its own hook. It wouldn't have to be responsible indirectly through the local.
Perhaps, Your Honor, but the issue that we're looking at is whether or not we're going to aggregate. And it does, just because the parent organization.
But if you're only going to aggregate when the larger organization is going to be responsible anyway for itself, then you're not going to aggregate.
I'm sorry, Your Honor, if you can.
In other words, if you're only going to aggregate when somebody acting directly on behalf of the larger or the parent organization is actually doing the discrimination, when you can reach that organization anyway by itself, so you're not. At that point, should the local be responsible to turn it around? If the harassment is being done by an officer of the parent organization, why should the local be responsible?
Because
so the obverse problem.
Right, yes, Your Honors. In such a circumstance where the issue that we'd be looking at is, well, we have one individual from the local organization who's participating in some element of discrimination, but they as an organization would be exempt from Title VII. However, under the PAPA test, we would be able to aggregate it. Now, what we do see also in the facts of our particular case is that the parent organization did not, in fact, act to promote a policy of discrimination and was, in fact, quite explicit. And I quote Mr. Peacock from his declaration that the national organization dictated.
But as a functional matter, I think this is why Judge Donald was asking you this. The national organization is never going to direct an officer of the local organization or an employee to harass somebody else, so it's never going to be responsible for sexual harassment.
Your Honor, what we're looking at in this case is specifically an instance where a parent organization has goes to a certain degree of, at the very least, control where they can direct behaviors of the local organization. And we don't have that in the facts of our case.
Well, you make a good argument, counsel, to my mind, that it is not unreasonable to recognize that the Baker test, for example, was not crafted and adopted by all courts to deal with Title VII, and there are a number of interests that maybe cut the other way and maybe suggest that a test should not be as broad as the Baker test. But let's assume for a moment that we don't accept that argument, although it's a reasonable one, and we think the Baker test is the right test. Tell us why your client would still win even if we use that test. Or do you believe that all your argument ultimately hangs on convincing us that the PAPA test is the right one?
No, Your Honors. With the undisputed facts of this case, regardless of the standard applied and the way we define employer for purposes of aggregation, my client cannot be aggregated with the parent organization. When looking to the Baker factors, firstly, we look to these several circuits which generally apply a holistic reasoning, a holistic analysis to the Baker factors, leading to that ultimate question of control. And in our case, we don't have facts that indicate such a degree of control that would satisfy Baker. For instance, if we look in particular to the control of labor relations, which several circuits have emphasized as the key factor, what we really get to is who has the ultimate executive control over hiring and firing decisions. And in this case, the local organization had such control. Look specifically to Ms. Duan. She was interviewed, hired, supervised, all by the local organization. The local organization is responsible for setting working conditions. They're responsible for setting employment hours and standards. Everything to do with the way employees are handled is all ultimately falling directly to the local organization.
Can I just ask one supervening question? We're at the Supreme Court. We don't have to accept either the Baker test or the PAPA test. We can come up with our own test. Right, so if we were starting from scratch, which we are starting from scratch, what should be the right standard?
Your Honor, in the event of a hybrid test, which certainly this court has
Okay, go ahead.
If we're going to start from scratch, Your Honors, the objective here ultimately is we want to find a test that naturally leads back to the single employer exemption and specifically targets those bad actors that need to be excised from that pool that we don't want them operating within. So the PAPA test offers a very clear guidance to employers. It gives us a great starting place.
But for example, the PAPA test at the front end in terms of the economic integration issue that we were discussing earlier takes the toughest possible standard. You could have a different standard addressed to economic integration and then add on the other two factors of the PAPA test. Should we do that?
Your Honors, if this court uses this discretion to do so, it can do so.
Well, don't we have the discretion to do so?
Certainly, Your Honors, if this court chooses to do so, I believe that under the facts of this case, my client would still be vindicated. If we're looking specifically to aspects, particularly of financial control in this case does not go so far as to indicate that the national organization was, again, controlling the local organization. In this case, what's pointed to as a significant aspect of financial control is the component of auditing. The ability of the national organization to audit the local organization. But under this case, if we look to similar situations perhaps with a debt investor, they also have an ability to audit.
So counsel, picking up on that, let's think about my colleague's question to you and about the level of control that we really have here to approach this problem afresh. So whether we use the PAPA test, the Baker test, or the BACA test, or Packer test, whatever it is, would we not want to read Title VII in a manner that suggests that whenever we draw these lines to determine whether we're dealing with one employer or multiple employers, we should bear in mind not to allow an employer to say, well, look, we want the benefits of being able to substantially direct some local affiliate, but no, we don't want liability for Title VII or anything. We'd like to insulate ourselves from liability as much as possible. We'd rather not know one way or the other, whatever it is that we might know that might put us on the hook for liability. So how should the test that we craft deal with that kind of problem?
You know, if I may clarify, with the problem of...
The problem of willful blindness, the problem of an organization saying we want the benefits of integration. We want to be able to tell our affiliates, follow these particular rules if you want to be a member of the National Federation. Here are the regs that you have to follow. Don't discriminate, et cetera, or, you know, discriminate but don't tell us about it, or whatever it may be. But don't put us on the hook for any liability based on your conduct.
Your Honors, I believe that in a scenario where we have willful blindness, we can turn to other areas of the law where we have familiarity, where we know, and if we can prove that there is a organization that's willfully blind so as to insulate themselves from liability when they know there's liability continuing on, I don't see that as being particularly dissimilar from the second prong of the PAPA test.
It's a difficult problem, isn't it? I mean, think about it. If to the extent that you're invoking other bodies of law, which I think is certainly a reasonable move to make, it underscores how complex this is. And given that complexity, shouldn't we trust the agency and defer to it to some degree?
Your Honor, if I see I'm out of time, if I may briefly answer and conclude.
Yes, please.
Ultimately, when looking to the agency, we can look to the agency in the way that they felt about a particular situation, but ultimately the agency is empowered by Congress. And in this case, Congress had the ability and the opportunity to incorporate the Baker test into this component of Title VII as they did in other remedial statutes. And as this court stated in Edmonds versus Compagnie Générale Transatlantique, with broad-reaching legislation such as this, when Congress chooses not to act, that is a silence most eloquent. And I believe that that speaks far louder and more convincingly than the EEOC's stance.
I know you're out of time, but I just have to ask you, while you've been arguing for the PAPA test, is there any circuit other than the 7th that has adopted the PAPA test in its current form or in its entirety?
Your Honors, no other circuit has explicitly adopted the PAPA test. The Third Circuit has a test similar to the PAPA test, and but it's notable that many circuits have not rejected the PAPA test and are actively still considering it. So it's not off the table here, Your Honors.
Thank you.
Okay, thank you very much.
Thank you, Your Honors.
Thank you.
We will next hear from Ms. Ashton.
Actually,
Is that not right?
from Ms.
Oh, I'm
Yang.
sorry.
Ms. Yang.
From Ms. Yang. Oh, you're going to